Hello, everybody. Welcome. We have another case. This is a writ for mandamus. So just because you file a writ for mandamus does not mean it's going to get approved. So this is a good example of a writ for mandamus that was filed, but I don't believe it was approved. Actually, it says that they were noticed to intend to deny. So let's take a look at this case. So this was filed in the District Court for Northern District of Ohio. And let's take a look at the details. So the plaintiff was a lawful permanent resident of the U.S. and filed his application for USCIS to become a U.S. citizen. He attended an interview. He received a naturalization interview results form that stated that a decision could not yet be made without about the applicant's application. Then I guess he hired counsel. Plaintiff, through the counsel, submitted an inquiry to USCIS as more than 120 days has passed since his interview. USCIS responded to plaintiff's counsel inquiry, stating, according to USCIS records, the security checks are still pending. Until these checks are completed, we cannot move forward on your case. Plaintiff sought assistance with his application through a senator's office. He received an automated response to fill out a request for assistance form. There was no further communication. Then he reached out to the ombudsman, and there was no further correspondence after that. Then he filed the writ for mandamus lawsuit for the N-400. The USCIS is now working. In the filing, they said that the USCIS is now working on preparing a notice of intent to deny a plaintiff's application. So just because you filed a writ of mandamus does not mean that it is going to be approved. Seen here in this case, they said they're working on preparing a notice of intent to deny the plaintiff's application. Okay. Some of the analysis the court goes into. First, the defendants argue a remand, send it back to you, so will provide plaintiff with an expeditious decision on his application, as well as allow him an opportunity to address any derogatory information on his notice of intent to deny, which the defendants claim USCIS is now working to prepare. But the plaintiffs oppose defendants' motion to remand, and while some courts have chosen to adjudicate naturalization application and denied the requisite motion to remand, those cases involved extreme delay. So they're talking about 3 years, but they're saying no such extreme delay exists here. So the court next turns to issue whether it will implement a deadline for USCIS to adjudicate plaintiff's application. So first of note, while plaintiff states it has been 1 year and 8 months since plaintiff filed his application, the relevant date is the date of examination, which is the interview, which is considered the date of plaintiff's interview. Because plaintiff's initial interview took place July 29, 2021, it has been 390 days since the interview, the time period the court will use to evaluate whether there was been extreme delay. All right, because no extreme delay has occurred here, and because USCIS states that it is ready to soon issue a notice of intent to deny plaintiff's application. Remember, they don't always approve it. I mean, they're saying that they're going to deny, and they issue a notice of intent to deny. The court determined the proper course of action is to remand the case to USCIS without imposing a specific deadline for completing its consideration for application. Yeah, so this is an example of notice of intent to deny after filing a mandamus lawsuit. So if you like this, give me a thumbs up, like, subscribe. Thank you very much. Bye-bye.